welcome to today's program, When Life Gives You Lemon Law Reform. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I'm delighted to introduce our speakers, Erica Kavicki and Michelle Fonseca Camana. Michelle is the founder and principal attorney at West Coast Lemons APC, a law firm specializing in California lemon law. Having personally negotiated over $14 million worth of settlements from auto and RV manufacturers throughout her career, she is most proud of coupling incredible results with an unparalleled client experience. Her article, When Life Gives You Lemons, Law Reform, in Advocate magazine has been one of the leading publications on the recent changes from AB 1755. Michelle serves on the board of Consumer Attorneys of California and dedicates significant time to mentoring other attorneys on how to start their own law practice. Erica is the founder of Lemon Law Lawyers Group, Inc. She has over 20 years of legal experience, with the last 14 years dedicated exclusively to lemon law litigation. She has successfully settled hundreds of cases for consumer clients against big car manufacturers while obtaining results beyond expectation for those clients pushed to trial. Erica has tried over 30 bench and jury trials throughout her career, conducted hundreds of administrative hearings, and has successfully argued in front of the San Diego Court of Appeals. We can't wait to hear what they have to share with us today, so I'm going to turn it over to them.
All right, welcome everyone. So we're going to get our slides going here. All right, next slide, please. All right, so if you've been practicing lemon law over the last year, you know it has been absolute chaos. So we had Rodriguez come down last October. We've had this AB 1755 get passed, and then we had SB 26 get passed. So we have a lot to talk about here today. Next slide. All right, so I don't want to spend a lot of time on Rodriguez, but most of us are well aware Rodriguez basically tanked used car cases against the manufacturer. So we've got our carve out. If they're certified pre-owned, these cases still live on. But something that I just wanted to note here during today's presentation, because I see a lot of misunderstanding of Rodriguez. Used car cases under Song Beverly are not completely gone. You can still have a Song Beverly case against a dealership. So same type of analysis. You look at who's the warrantor, were the defects covered under that warranty? Have there been enough presentations? So take a look at your cases. If you're getting used car leads, don't just automatically reject them. Take a look at the facts. Also take a look at Civil Code Section 1795.5. We still have a duty to these used car customers, so take a look at the law on this. Don't completely assume that because Rodriguez came down, used car cases across the board are out. Look at cases against the dealerships based off of their warranties. Look at the buyer's guide. Look at CLRA. There are a lot of different ways we can still take on these types of cases. Next slide.
Just briefly on the Rodriguez, if you have current cases with used vehicles, expect the manufacturers to most likely file a motion for summary judgment. Be creative when you amend your complaint. Add in additional claims to keep your case alive.
Definitely good advice there. And then AB 1755. So this has been absolute chaos over the last year. So we really want to get into this. So AB 1755, formally approved by Governor Gavin Newsom back in September of 2024. This has been probably the biggest reform to lemon law since it started. So major changes came through: statute of limitations, damages, and procedure. Next slide. So key dates for this statute. So original AB 1755 implementation date, it went into effect across the board for every single defendant, essentially, January 1st, 2025. We then saw some issues with SB 26 come through, but from January 1st, 2025 to about April 1st, 2025, this was the new law that applied to everyone. Next slide. And then came SB 26, probably the worst thing that's ever happened to lemon law. Approved by Governor Newsom April 2nd, 2025, it allowed the defendants to choose which law applies to them via some changes to the Code of Civil Procedure. The worst part of it was retroactive as well. So from January to April, we really didn't know what law was going to apply since this code section ended up being retroactive. Next slide. So key dates on SB 26, it passed April 2nd, 2025. It created a 30-day opt-in for defendants to take a look at the new law, decide whether they wanted to opt into it or just stay out of it. Once that deadline hit, the Department of Consumer Affairs then had another month to make sure everything was posted on their website. However, as we saw, Department of Consumer Affairs was pretty quick with it. We had a pretty stable list well before June 1st, 2025, but at this point, that list is pretty locked in, at least as to cases filed in 2025. Next slide.
Someone's asking a question about the materials. They're unable to get the materials, I think, or
You should have gotten an email with the materials, I believe, but we can circle back with the Beverly Hills Bar Association folks and give you a little bit more information at the end. But you will be provided with the materials. And it should be in the chat. All right, so the initial not opt-in, there's the code section just for reference. So 30 days, 60 days, and then the important one, I think, is subdivision C, where it made this statute retroactive. So definitely, if you have cases filed between January 1st, 2025 and April 1st, 2025, take a look at this statute. It's going to be very, very helpful for you to determine what law actually applies to those cases and what can you enforce. Next slide. So this is going to be something ongoing, unfortunately. So these opt-ins aren't forever. When defendants opt in, they are opting in for a period of 5 consecutive calendar years, and they can't withdraw the election. So right now, based off of the people that are on the list on the initial opt-in, they're going to be locked in for the next 5 years. So, come 2029, we're going to want to start taking a look at who's going to remain on this opt-in list and who may have basically revoked their opt-in then. However, I imagine there's going to be a few manufacturers that have kind of seen how things have played out with the new law and may decide to opt in. So their opt-in deadline for 2026 and the next 5 years is actually coming up at the end of this month. They have to opt in by October 31st of this year to be able to have the new law apply to them in 2026 and beyond. So their opt-in date is October 31st. Then we go through the whole process of them putting it on their website through Department of Consumer Affairs. So by December 15th, we should have a new list of all the car manufacturers, RV manufacturers that are opting into the AB 1755. So put a little tickler on your calendar for December 15th because you're going to want to take a look at who's opting in for 2026 and adjust your processes that way. Next slide.
And they usually pretty good about, I think we provided the link on one of these slides for the web page that shows which ones have opted in, which ones are not in, and where to send your demand letters to.
Exactly. Department of Consumer Affairs, to their credit, they've made it pretty simple for us to check out, all of the contact info, which is good. So damages. AB 1755 changed a lot when it comes to damages, but it's important to kind of see where we started, what our original law was. So Civil Code Section 1794, that's our main statute for damages in Song-Beverly cases, as many of you know. The words that I really want you to focus on is it's not just repurchases or replacements, which is our standard settlements in these lemon law cases. Under 1794, you may bring an action for the recovery of damages and other legal and equitable relief. So it's not just your repurchase, it's not just your replacement. You've got those very open-ended damages statute. You also have UCC damages in addition to your repurchase or replacement. So this is going to be important to note when you're analyzing what the new law takes on and what it takes off. So next slide. So what is not included? So this is the new kind of main star of this new AB 1755 statute, Code of Civil Procedure, Section 871.20. So I've highlighted some of these keywords I want you to really hone in on. So notwithstanding any other law, this chapter applies to an action brought against a manufacturer. So notably, this doesn't apply to dealership defendants. And as we talked about with Rodriguez 1795.5, used car cases still can live on under Song-Beverly against the dealerships. As long as the stars align, I mean, it is kind of tough, but those cases can still live on there. So this is just against manufacturers. The second part to note is seeking restitution or replacement of a motor vehicle pursuant to those code sections. So we're looking at buybacks, we're looking at replacements. As we just saw in 1794, you can ask for a lot of different types of damages that aren't necessarily restitution or replacement. So keep that in mind if you have a case where you might be, have statute of limitations issues where maybe you can try to get a repair covered under this as the damages. Get creative, especially on cases where they might be otherwise left without any remedies because of these new statutes. The last thing to note is where the request for restitution or replacement is based on noncompliance with the applicable express warranty. So what does that leave out? Leaves out the implied warranty, right? So keep that in mind when you're looking at this code. It's not just this all-inclusive where it's every Song-Beverly case is now covered under AB 1755. There are some carve-outs, so make sure you understand where you might be able to take advantage of these carve-outs. And the last section, chapter does not apply to service contract claims or anything like that. So that's just kind of another carve out. So be thinking about these other different types of claims that might not be your usual restitution replacement based off of violation of the or breach of the express warranty. Next slide. So if you've been practicing, you've probably heard the term legacy cases, especially from, some of these manufacturers like General Motors. So defense position, they are very gung-ho on drawing a line in the sand of January 1st, 2025 and on, and anything that was filed before that. So they've been calling anything before that these legacy cases. And so depending on the facts of your case, there might be certain things in the new law that might benefit your client. So if you're in that situation where you do want to pull from some of the new law, there are arguments you can make. However, quick little disclaimer, as we all know, arguing with these manufacturers is sometimes like talking to a brick wall. So
if you can even get to talk to them.
Yeah.
And that's the biggest problem too that we're facing here is that a lot of the manufacturers, you cannot, it's not like the olden days, which is like last year, where you could get them on the phone or you can get them via text message or email and actually have a communication with them about a case. They are so overwhelmed over there. They don't know who's handling what. And the legacy cases are the ones that are falling through the cracks.
Mm-hmm.
Those are the ones where I think as consumer attorneys, we have the biggest advantage on because we can keep progressing those cases while they're so worried about the new ones. We can progress the legacy ones and push them towards trial and get some resolution that's more favorable to our consumer.
Absolutely, absolutely. So we wanted to throw out the law in there, so it's good to know what the law is on this. Whether you're going to be able to speak logic to some of these, people on the defense side is a whole different thing that we cannot promise or guarantee or warrant. But at least here's some tools that you can use in your tool belt. So a lot of the things that they've been pushing back on is, there should be implementation dates. If the whole AB 1755 were to apply to these legacy cases, the legislature would have said so. And so you can point out there are actually very specific implementation dates for different provisions. So we've listed some of those out. So if their argument made sense, there is a provision that says it only applies to civil actions filed on or after January 1st, 2025. That would have been listed at the very beginning to apply to the whole law. It only applies to certain provisions of it. So that's part A of your argument. Part B of your argument, case law's on our side. So as long as it's something that affects things that haven't happened yet. So, for example, your settlement procedures, damages, something like that, where that has not yet concluded, you can actually pull from the new statute. So, there's two cases that talk about this. So, definitely look into these cases, look at the briefing on this. You can shoot your shot with the manufacturer, see if you can get a couple wins for your clients if there are provisions in the new law that could help your current clients on these legacy cases. Next slide.
I have a question here. It says manufacturers are overwhelmed and hard to get a hold of. If they don't respond to our demand letter within 30 days, is this enough for civil penalties?
We will get to the civil penalty section in a little bit, but that is a very good
Great
question. All right, so statute of limitations. Wait, go back, I think. There we go. All right, statute of limitations. So now we have been blessed with two statutes of limitation to worry about instead of just one. So, statute of limitation number one. It's 1 year after the expiration of the applicable express warranty. The second one is 6 years from the date of original delivery of the vehicle. So we've got the code sections there. Take a look at it. But generally speaking, you've got your 1 year and you've got your 6 year. Next slide. Here's where these things can get very, very tricky and dangerous. So on the 1 year statute, if you're dealing with just your run of the mill normal lemon law case on, a car, truck, even a car that's over 3 years is now going to be considered kind of an older car because of these warranties and because of these statute of limitations. So if you've got a car that is, for example, 4 years old, your spidey senses should be taking a look at that, because if the problem is covered under the basic warranty, and for example, if they have a 3 year 36,000 mile basic warranty, that means your statute, assuming it's a lower mileage vehicle, that runs at year 4 if the problems you're suing for are covered under that basic warranty. So if you've got infotainment issues, air conditioning, stuff like that, be very aware this statute is going to sneak up on a lot of people. The other problem, RVs. I'm already seeing a lot of issues with statute of limitations on RVs. A lot of RVs only have a 1 to 2 year warranty. Being a recreational vehicle, people aren't just, it's not their daily driver. They're going on camping trips a few times a year. So that time period goes by very, very quickly. And the RV manufacturers, especially, are very good at kind of drawing things out when they're talking to customers about, oh, let us make it right. We'll give you an extended warranty. We'll give you, a little cash settlement. Before you know it, on a 1 year warranty on an RV, by year 2, statute of limitations is run and you're done. So be very, very careful when you're looking at these types of vehicles, RVs especially, or normal vehicles where the defect is something covered under the basic warranty or one of the shorter warranties. Next slide. So the 6 year statute, also something we're going to see a lot of problems with. So certified pre-owned vehicles especially, so most of them are 6 years old or less at the time of sale. But for example, if you've got a certified pre-owned car that was 5 years old at the time of sale, that means you only have about a year for the client to drive the car around, see what the problems are, take it in for all the repairs, and really build the case in a very short amount of time compared to what normal, a brand new vehicle is. So if you're dealing with certified pre-owned vehicles, you may want to move quickly once they get to be leads for you, because these statute of limitations are going to run out very, very quickly. Next slide. So not everything was bad. So some positive news at least. We have a few positive changes when it comes to damages. So the best one for us and for a lot of our clients is this code section 871.27B. So as we know, when a lot of our clients go into the dealership, they're sold take it or leave it. You have to add on, $6,000 worth of aftermarket accessories, theft deterrent devices, extended warranties, gap insurance, you name it, they're going to add it to the contract. And then a lot of the manufacturers will try to nickel and dime our clients on that. This new code section helps us out a lot because as long as these basically aftermarket additions are supplied by the selling or leasing dealership, they can be recoverable as damages, which means they can't be deducted. So take a look at your purchase contracts, take a look at your lease agreements. Generally speaking, if these additions are listed on that original document, they can be recoverable as damages. And you can also cancel them for prorated refunds, especially when it comes to those contract type things, extended warranty service contracts, and gap insurance.
And we are seeing this applied to legacy cases. So I never gave them these deductions to begin with, but now it's not a fight. They're just including it and not trying to subtract it anymore.
Yeah. Yeah. So for the most part, we're not seeing too much pushback. I did see a little bit of a pushback on one case recently. So just something to be aware of. If they're trying to take these deductions, have this code section in your back pocket, cite it. This is the new way. But also keep in mind if your clients are getting their cars, wrapped, window tinted stuff after purchase, after lease, you can still argue to have those expenses reimbursed, but this isn't really going to benefit you for things that happen after the sale or after the original lease. Next slide. So another positive change is in 871.27G that really talks about the processing of these cases. So before it was kind of the wild, wild west when it came to how everyone was processing these cases. So now we have it in statute, settlement processing within 30 days from receipt of assigned release from plaintiff's counsel. You get the buyback check provided to client at the time of surrender, so it's not checks in the mail kind of thing anymore. And there's also a mandatory $50 a day penalty until the settlement is completed if they go over that 30-day mark. However, there is that little asterisk at the end, subject to good faith responding to reasonable documentation required to process settlement. So just make sure you have your ducks in a row. Make sure you have your financial documents, payment history, payoff quote, any incidental damages. Just have that ready to go so you're not looking at delays caused by you. And that way you can maximize your client's recovery and you can make sure these things are actually taking place in a timely fashion. Next slide. So we had a good break on good news. Back to the bad news. CCP section 871.27C. Negative equity is now a statutory deduction. So negative equity, historically, the manufacturers have tried to deduct it. There are some good arguments, or were some good arguments prior to this being codified, but just something to be aware of if your clients are rolling debt into their new car purchase. That's a lemon. The manufacturers kind of have this in their back pocket now. The other thing that has happened is Creighton versus FCA seems to have been in a way codified now in this new law. So quick refresher, if you're not familiar with Creighton, it basically talks about whether residual value on a lease can be included in the consumer's actual damages, and if so, how do they play into civil penalty damages? So unfortunately, Creighton didn't exactly go our way. Residual value on a lease did not fall under actual price paid or payable, so they wanted to see actual payments toward it. So next slide. This is what AB 1755 essentially did to these types of damages. So if you have a lease, when it comes to just your normal damages, amounts paid or payable under the original lease terms are still reimbursable. So nothing is changing there. If your clients are making payments towards the lease, they get that back. It's included in actual damages. It's included in civil penalty damages. The thing to note too is it's also included if you purchase the car out of the lease and the residual is financed. So if your clients, a lot of clients are buying lease cars out of leases pretty quickly to take advantage of tax deductions. So if you have clients in that situation, if they're financing the car, those payments still count just as much as if they were under the original lease. And then that residual value as well. Next slide. When it comes to civil penalties, they do make a few different distinctions. So the first one is based off of a lease extension. So they put a little bit of a leash on when you can do these lease extensions. So keep in mind if you have a legacy case and you're like deep into it, the timing of the lease extension could be a problem for you. So take a look at this code section. But for most cases, especially if they're early on, if you haven't sent a demand yet, if you haven't filed a lawsuit yet, the payments under the lease extension can be included in both damages and civil penalties. Just make sure the lease extension is triggered no later than 30 days after the pre-suit notice, so like your pre-lit demand, or 30 days after filing a lawsuit, whichever is earlier. Next slide. So when it comes to residual value, so really take a look at or think of this as the lease buyout. So when your clients are buying the car out of the lease, basically they're financing the residual value more times than not. So if they are doing that, suddenly it kind of turns into a purchase type of evaluation. So these payments are included and the residual value can be included. But there's also that timing element. You have to buy it out of the lease no later than 30 days after your pre-lit demand or 30 days after filing a lawsuit. So that is kind of the hack, I guess, to including all of that residual value into both your damages and your civil penalties, but you have to act quickly. Next slide. Procedural changes. So we've got some new timelines. They equally hit us as much as it hits the manufacturers. So when you're filing these lawsuits, you want to just make sure to calendar these dates from the beginning. You do not want to miss these deadlines. So the key deadlines to be aware of: 60 days from the filing of an answer or other responsive pleading. Initial disclosures are due from both sides. And I think they've been kind of aggressive on the initial disclosures, right?
Yeah, I've had the experience of them being quite aggressive on that. First off, biggest tip I can give you when you're doing intake on these cases, and it's a case that's going to fall under the new procedures, make sure you talk to the client, get the financials, get the documents you need for those initial disclosures right away. Because otherwise, you're chasing them for them. And if you don't get them in time and you don't serve them in time, then now you're looking at sanctions, and sanctions are pretty much automatic. They're not something that, courts are not unwilling to sanction for. So definitely do that. What would I, well, I thought, I think you asked me a question about that.
Oh yeah, the initial disclosures, because they're even filing sanctions motions.
Yeah,
right?
so I did get one. I actually got a motion for sanctions with a General Motors case because I didn't provide current registration. However, my client did not have current registration. He had expired registration, which we provided, and I provided a note. And over there, their discovery team, their litigation team, nobody talks to each other. So while I gave this information over to the litigation team, the discovery team apparently did not get that information. So I received a motion for sanctions for not providing current registration in violation of the initial disclosures. And I served them with a 128.7 motion, which you have to serve. I think it's 21 days in advance, and let them know that their sanction motion was frivolous. They called me, they apologized, but the lesson from that is that they are going to be, and they intend to be, aggressive on failure to provide everything that is listed in the initial disclosures if your client has it.
Yeah, that is a very, very good lesson and story for us. So, initial disclosures, be ready so you don't have to get ready. 120 days out, you have the right to take the deposition of their PMK. So, as we all know, it takes forever to get PMK depo dates. So, be aggressive with this. Notice those depositions early on, set a date unilaterally, but let them know, like, look, if this doesn't work, please provide me with a couple different dates. That way, you're building your paper trail from the beginning and making a point. I'm not trying to waive any of these procedural deadlines. We are going to meet every single deadline, but just be aware you need to be ready to comply with your own deadlines as well.
Also, with regard to the plaintiff's deposition, they will initially, when they send the answer, they will send you a notice for plaintiff's deposition. If that date doesn't work, object to it. But I would suggest that you put in 2 to 3 dates that work for your client for that deposition in your objection. Chances are they're not going to read it and they're going to blow over those dates anyway. But if they go after you for a motion to compel that deposition, now you've got this exhibit to show the judge, hey, we are trying to we're trying to cooperate here, we're trying to be in compliance. And then I just got a question on what's a PMK. That's the person most knowledgeable at the manufacturer. So that's someone who, and I think we'll get to it later in the slides, has to be able to testify competently under oath for the manufacturer regarding certain topics.
Exactly, exactly. And if you take a look at this code section, the 871.26, it goes into a lot more detail about these things. So definitely check that out because it says exactly what the initial disclosures have to be for plaintiff, what they have to be for defendant. It talks about plaintiff's deposition, time frames, PMK deposition. I believe categories are listed out on there as well. Mediation. They're also saying on the mediation, I believe, they have to have someone with authority at these mediations under these AB 1755 cases. And some of these manufacturers love to go to mediation without someone with authority.
Right.
And kind of waste people's time. So just be aware that there are a lot of little nuggets in there in this code section that you can use to your advantage to hold them accountable, especially since violations of these things carry mandatory sanctions. And it's sanctions against the defense attorney that can be reportable to the state bar. So if they keep messing up, we all know that defense firms and defense attorneys that tend to not respond, not do their jobs, this could be a powerful way for us to try to get things moving, hopefully get them better staffing. I don't know. We need some changes on their staffing for sure. But take a look at this. So mediation must be scheduled 90 days out. The biggest thing I think I've seen through AB 1755 is mediation dates are nearly
Right.
impossible
And
to
we have,
get.
yeah, we have a question here. It says, who is responsible for coordinating slash scheduling the mediation? Is this private? And if so, who pays? Okay, great question. Um, it's supposed to be a mutual agreed upon mediator, and the mediators that are typically being used in consumer litigation seem to be jam packed until January,
Yeah.
February, March right now. And so don't delay. As soon as you file a case, I would start contacting the mediators, finding out what dates they have available, maybe even holding a date, because the mediators will allow you to hold a date and then you can cancel it, 2 weeks in advance or something like that. Depends on the mediator. But yes, it's your responsibility as well as the defense's responsibility to get together and coordinate that mediation date. So you have to just really keep trying with them because you need a paper trail,
Mm.
absolute paper trail with them. Because if this goes in front of the judge, and I've had several judges actually now who are asking about the mediation date and when it was completed or when it will be completed. And if you don't have that paper trail, you're both going to get sanctioned.
Yeah, take a look at the code section because I believe it talks about also like who has to pay. I believe it's half and half, but obviously we get our costs back. So you would get that back once you're successful or the prevailing party. But take a look at that code section. But pro tip, that 90 days out to schedule mediation, if you're waiting till 90 days out, it's too late. You need to start, they file the answer, like hit them with your PMK depo dates, get mediation dates going. That way you're building your paper trail and you're setting yourself up for success because if you're being proactive, you're going to get those dates. You're probably going to get mediators that you actually want to work with, and that just puts pressure on them because they know you're not letting anything slip through the cracks. Squeaky wheel gets the grease, on a lot of these cases. So make sure you are very, very prepared when it comes to these different timelines. Next slide. So the bad thing is discovery is stayed during this period. So we're very limited on what we can do But, we still have, usually enough to be able to go through the PMK depot and get a pretty effective mediation done and get these cases done. But just also be aware sanctions are mandatory for non-compliance. There's monetary sanctions, and the good thing for us, for repeat violations by the other side, there can be evidentiary sanctions where basically your underlying lemon law case is proven for you. So keep an eye out for that. And it's just another reason why you want to be proactive with pushing these different deadlines. So you show the court, look, I'm just following the law here. They don't respect the law. We are entitled to evidentiary sanctions in this case.
And just a quick note with regards back to the person most knowledgeable deposition. Just know that most likely they're going to offer up somebody that knows nothing about the case and most likely nothing about lemon law. So it's also important when you are deposing these people to get the information that they don't know. Because that's going to help in your mediation, that's going to help in litigation, that's going to help if you're going in front of a jury, and you can talk about, you can cross-examine him all the stuff that he didn't know at that deposition that he was supposed to know. I have been finding, at least in my experience, that the discovery that we've been receiving post 871.25 is actually more extensive than we were getting before. So go through everything. I mean, I'm getting thousands of pages per case, phone calls, recordings. Go through it. There's little nuggets of gold hidden in there that you can talk to the person most knowledgeable, but also you can use that at mediation to potentially get a civil penalty or extra incidental damages if you don't want to call it a civil penalty. But there are some things that you can find within the discovery they're giving now that was different and more extensive than prior to 871.25 or 26.
Absolutely, absolutely. Yeah, because on the PMK depot thing, like I've gotten so many recently where their only skill is they can read documents. Their responses are, well, that's what the document says. That's what the
If
document
they
says.
receive the documents, because sometimes they don't even receive the documents and they're just kind of flying blind and basically saying or admitting they're saying what the attorneys told them to say.
Exactly. So build your paper trail because once again, if they're not actually producing a true PMK as to the categories listed in this code section, guess what? Sanctions, and if they do keep doing it, evidentiary sanctions. Next slide. So civil penalty procedure, going back to one of the previous questions, I believe. So keep this in mind. So on cases that you're filing after July 1st, 2025, you need to go through this procedure. There's contact information for the defendants that have opted in. So on some of these earlier cases, a lot of the manufacturers, especially on some older cars, the owner's manual, the warranty booklet's not going to have this info on it because it was printed pre this law. So you can always check the Department of Consumer Affairs website. We put the link in here just so you have it. But you're going to want to, honestly, I have that link bookmarked on my desktop because I'm constantly looking at it. And especially as these new opt-in deadlines come through on December 15th, you're going to want to refresh that. So make sure you, attorneys, paralegal staff, everyone has access to this.
Do you want me to reread the question so you can answer it now?
Oh,
'Cause I think it's
sure.
pertinent
Yeah.
here. Manufacturers are overwhelmed and hard to get a hold of. If they don't respond to our demand letter within 30 days, is this enough for civil penalties?
So, yes, especially if you're doing this now. So make sure your demand letter complies with this procedure. So this procedure is pretty simple to follow. Go to the next slide. It might have more information on this on the next one. Here we go. So you send your initial demand letter. So you can send it via mail or you can do it via email. So you brought up a good point of sending it via mail because that kind of buys you a little bit of time, right?
And then also, they will respond to you within a day or two, and then you'll get, or what I've seen, and I haven't been doing a lot of these for reasons we'll talk about later, but my initial ones, I would get a response that says, okay, we're going to buy back the car. Please send the financials. At that point, the consumer's responsibility triggers, and you have to send the financials, payoff, loan payment history, registration, incidentals, anything. You have to send all that as efficiently as possible to assist in the process. I have also been receiving from, should I name the manufacturer? General Motors. They, General Motors, sent me an email saying, we would like to evaluate your case for a buyback. So it's not even an offer for a repurchase. It's send us the documents to evaluate your case. No, that's not what A71.24 says. It's only the consumer's responsibility only triggers once there's an offer on the table. So I ignore those. And it's been going pretty well.
Yeah, so when in doubt, just go back and read the code section. You'll find a lot of nice little loopholes there. So on that one, there's a good faith requirement for documentation required to complete restitution or replacement. So those repair orders are not required to complete anything. It's the financials. So keep that in mind when you're dealing with the manufacturers on these kind of pre-lit cases where you're trying to build that civil penalty case. But if you do it right, you send your notice. It's basically got, the consumer's information, the VIN number, brief summary like, oh, I'm having check engine light problems. It's been in 4 times. And then that specific request, I'm looking for a repurchase. I'm looking for replacement. You don't need to send this whole long thing. You don't need to send docs with that pre-lit request. It's really just look at the code and just send what is required. Then they have 30 days to make a yes or a no decision. So even on some of those where they're harassing us for the, purchase contract repair, right before it's 30 days, they're magically like, oh, we're gonna buy it back. So just keep that in mind. And then from that time, then they have 60 days from the original notice date to process the settlement. So you want to be ready with financials the day that you get that, hey, we're going to buy it back, send the financials over. You want to be ready with those financials so that you can actually hold them to the 60-day mark.
And sometimes it takes 10 business days to get payment histories from credit
Oh,
unions,
yeah.
from some banks. So just put your client on notice that, you'll need that and that way you'll have it. So you're not burning some of the days. You want
Mhm.
them to burn the days. You don't
Mhm.
want to be the one burning the days because you want it to be able to qualify for you to file the lawsuit if, they can't make it.
Exactly, exactly. Yeah, I'm asking for financials like right when I'm signing these clients up because I
Right.
know this is coming in 30 days. Next slide. So, notably, this, for the first time, really, I believe, gives plaintiffs' counsel the right to pre-lit fees. However, the manufacturers are kind of going rogue, and their standard offer, pretty much across the board, is 1,500 bucks, which is insane.
I have not. If anyone has seen more than 1,500 being offered, please chime in because that is every manufacturer. That is the standard offer they are making. There is no negotiation. Even when you try to counter that, they would rather send you to fee arbitration for the dispute. And so that's where many of these are heading. And that is, again, why these demand letters aren't exactly the greatest thing on earth.
Yeah, yeah. And you brought up a good point about the fee arbitration too, where it just needs to be somewhere neutral. It doesn't need to be mutually agreeable. So I believe like GM is very particular about saying, no, we're not going to use JAMS, I think it is. They want to use BBB or NCDS. Um,
But
keep,
we reviewed the code.
yeah.
There isn't anything in there that says you cannot elect
Mm-hmm.
the arbitrator. So why let them pick somebody that they know in their experience has been more favorable to the manufacturer? I would say pick Jams has been more consumer
Mm-hmm.
friendly in my experience. So I say, you take the initiative, you file the claim in Jams, and see what happens.
Yeah, put the burden on them because then they're the ones that need to prove that JAMS is not a neutral forum. And that's more of a fight, and that's going to help you on your little 15, $100 fee thing. These cases are going to get a lot more expensive for them. So it's kind of a way to hopefully shift the power a little bit, because they're holding firm on this 1,500, and quite frankly, it's ridiculous. Next slide. So the new settlement procedure, we already touched on this a little bit, but you've got the 30-day processing, you've got $50 a day penalties for any time over that, as long as it's not your fault. plaintiff receives a repurchase check at time of surrender appointment. And then you're looking at getting your payoff, civil penalty, and attorney's fees check sent within 1 business day. So this should expedite processing quite a bit. So this is good. Keep this in mind that you can hold them to these types of timeframes now on the back end of these cases. Next slide. So we now have a standardized release. The way it's written is kind of written for pre-lit, it seems like, with the pre-lit demands for the civil penalty, because it talks about, I believe, like within 60 days of receiving notice. Obviously, on a litigation case, that doesn't make sense. So if you have a pre-lit case, just know that's the release that we're working with here. If you have a litigation case where you're trying to use the standardized release, it's going to need to be tweaked a little bit, but a lot of the manufacturers are still using it. It's just a slightly different. But also keep in mind, 998 offers are still fine. So what this does is the manufacturers can't force you to sign their, 6 to 10 page settlement agreement that, sells your client's, second born child. It's a lot more streamlined now, but even if you don't like some of the release terms in the standardized release, you still have the option of settling a case via 998 offer.
Well, also the advantage of the 998 also is the fee motions because it kind of triggers the timeline for the fee motions.
Yeah, so definitely you can get creative to to maximize your recovery here because we're in interesting times right now. Next slide. So you want to talk about this one?
Yeah, so some tips for the old way. So these are the legacy cases we're talking about. Any cases prior to January 1st. You're going to want to use to your advantage the fact that these manufacturers are kind of just neglecting these cases. So make sure your discovery is out on those cases. Continue to send out discovery. Continue to work those cases up, even though the manufacturer is ignoring them. Schedule your depositions, depose the person most knowledgeable. They're going to most likely start objecting because they're trying to get their person most knowledgeable's scheduled for the newer cases. So do your motions to compel, get those depositions on calendar. And knowing that we know now that all these manufacturers are offering some arbitrary $5,000 in fees, sometimes a little more than that, but $5,000 in fees or fee motion. Keep that in mind so that when you start doing significant work in the case and your slips or your billing slips are getting higher and higher, send out fee motion or send out demands for settlement, including your attorney's fees in there, so that you have the ability to show the court as exhibits in your fee motion that at every step of the way during significant intervals in that case, you tried to settle. You were trying to be the reasonable one. This is going to help us when the judges are getting pissed off that they're going to have a bunch of fee motions in front of them that they're going to have to deal with. And by the way, this also could potentially settle your case early on. Last I heard, San Diego is taking 8 months to give you a fee motion date. So that's 8 months where you have to wait to get paid on a case that you worked up.
Yeah, I had an LA case. I had to wait a year to be heard on a fee motion, which was crazy. So depending on what venue you're practicing in, you're looking at delays, that's cash flow issues. That's going to hit a lot of, solo small firms. So keep this in mind. It is kind of these fee motions are more and more prevalent. So make sure you're setting up your cases where you are protecting your interests here. Next slide.
Yeah, so the new way, so the pre-litigation demand letters that we're sending out to the manufacturers that have opted in are resulting in quick buybacks for the clients. And often the numbers are correct. There's little to no deductions. Oftentimes they're waiving the mileage offset for the client as well. So with that, keep in mind those cases, there's a conversation that needs to be had with the client before you decide which strategy to take. Oftentimes I'll present the pros and the cons to the consumer and let them know, okay, if we go this way, more than likely you'll get your car bought back in the next 30 and surrendered in the next 60. But then there's this other way you can go instead. And we have been having conversations, open and honest conversations with the clients about that. I can tell you that the pre-litigation procedures are great for the consumer. However, be advised and be aware that you are going to get those low ball fee offers of 1,500. You are going to end up potentially in fee arbitration because they're not negotiating at this point. And you're not going to get anything extra for your client if there's anything extra that they need. So definitely have that conversation with the client. Make sure when you do get that buyback figure from the manufacturer that it's correct and it's accurate. It includes all their incidentals. It includes the correct mileage offset. And if it doesn't, have that conversation with the client again and file a lawsuit.
Next slide. Please.
Oh, okay. So the the new way, straight to litigation. So there are some manufacturers where I won't do the demand letters with anymore. It's a waste of time. And make sure that when you file that lawsuit that you calendar all those dates coming up. Get those documents during intake that you need from your client, all the financials, especially the payment history, the loan payoff. I don't think the code says current payment history or
Mm-mm.
current loan payoff. It just requires it that your client obtain it. So if you get it 90 days before you have to turn it over, it still qualifies under the law. Get that registration, get everything. That way you have it and even serve it as quickly as possible. I don't even wait till the 90th day to serve it. I just serve it.
Yeah.
Because then they go into a panic because they think they've missed a date and they start panicking, and lo and behold, I get the discovery a little bit sooner.
Yeah.
But just know that you will most likely be resolving these cases. You'll resolve them favorably for your client if the claim is there, but you'll be most likely resolving the attorney's fees and cost portion by fee motion. I have seen some attorneys being able to resolve their matters by turning over their fee slips prior to any fee motion. Um, Personally, I find that a little problematic because I think that all the manufacturers across the board are actually starting to do this fee motion thing. And I think a lot of it has to do with that RICO case, which, we'll get into just a little bit towards the end. But I don't think it's about seeing that substantiating the fees that you did on that particular case. I think they're gathering this data, all of them, to sort of do something with it universally, whether it be try to find some way to fee cap
Mhm.
plaintiffs' fees in consumer litigation, or to figure out strategy on these cases with the consumer lawyers. And so my way of thinking has been now I'm not turning those over without a protective order. So I have pitched out to the manufacturer, sign a protective order and I'll give them to you. Because that will limit the purpose of them. That will not allow them to distribute it to the other manufacturers. It won't let them put it into some AI tool so that
Mhm.
they can have all this information gathered and cumulative with all the other manufacturers. So that's just a food for thought there, something to think about. Hopefully they're going to get tired of these fee motions. I think I've got about 12 to do
Yeah.
in the next month or so. So hopefully they get tired of it and they'll start really trying to negotiate these fees without this added need for a fee motion.
Yeah, I think it was a knee-jerk reaction, I think, to the RICO case where some of the manufacturers were like, oh no, we're overpaying. And then they drew this insane line in the sand that's basically forcing most of us to go to a fee motion just to be paid a fair fee award. Which is crazy. So just be aware of that. I think the data point is really, really smart because obviously there's a lot of things going on legislatively, politically, like this, all these reforms have just happened in the last year on personal injury side, Uber's coming after the personal injury attorneys. Like these big companies are trying to shut us down and take away our clients' rights to have reasonable, affordable legal counsel. So we need to think 10 steps ahead. And I think Erica's really smart in not wanting to give them that data because if we're just willy-nilly filing fee motions, not doing protective orders on our slips, we don't really have control over what happens with that, and it can be used against us, and we need to protect our industry because it's under attack. Next slide. So, in case you missed the news, especially when was this back in May, Ford filed a RICO case against one of the bigger lemon law firms in LA, Night Law Group. So take a look at this if you are so interested. It is, pretty juicy reading. But essentially, they took the fee motions that they have written. They basically compiled all that data, cross-referenced it, and found a lot of things that didn't add up. So this is kind of an example of how fee motions and all of that data can be used against us. So for all of us, of course, we're all ethical attorneys. We bill correctly, all that. But just be aware this is happening. This is an example of how this data is being collected and being used against different firms. So be aware that this is something we're going to be dealing with for the foreseeable future. And it also gives perspective on why, out of nowhere, a lot of these manufacturers are lowballing us on pre-lit fees. It didn't used to be that low, even last year. And even on litigation cases, they're drawing these insane lines in the sand to try to force fee motions. And why else would they force fee motions but for to collect this type of data to use against us? So just something to take a look at that's a little bit outside of, your day-to-day practice area, but it's something we need to pay attention to if we want to preserve our right to continue doing our jobs and representing our clients.
And just so you know, I believe the defendants filed a motion to dismiss, and I don't think there's an outcome on that yet.
Yeah, so stay tuned, get your popcorn, buckle up, it's getting crazy. So, does anyone have any questions for us? Pop it in the Q&A.
Okay. Non-lemon law lawyer here, handling case for existing client. Can you recommend a good resource for analyzing damages in an all-cash purchase case for purposes of framing a settlement demand?
Oh, like a cash and keep?
No, it's a purchase. It sounds like a buyback. It sounds like a buyback, but an all-cash buy. So no financing or anything. So
Oh.
just the risk.
Oh,
But
yeah,
yeah.
they're just a standard buyback. Good resource for analyzing damages. I mean, the statute's usually a good place to
Right. The
start.
statute is actually now with the new amendments and
Yeah.
everything, the statute is very clear on what you can and cannot get.
Yeah, so generally, your down payment, the payments that were made, if it was paid all cash, there's no payoff. So essentially, they're getting their money back. Take a look at the deductions, incidental damages. You're going to want to take a look at registration, possible insurance. There is case law as to when those incidental damages are triggered based off of when your client qualifies for the lemon law. So take a look at those types of cases.
Rental car expenses,
Mhm.
towing expenses, Uber expenses.
Yeah. So take a look at all that. And then when it comes to any deductions, definitely take a look at the code because there are some good things for you in trying to fight some of those deductions.
Okay, next question. If you settle pre-litigation, can attorney's fees be collected with a motion? Can civil penalties be sought separately via litigation?
No. So pre-lit, you don't have the benefit of a fee motion, you don't have a court case. That's why you end up in fee arbitration.
Okay, and then the next question. How are modern firms keeping track of the time spent on a case for the purpose of bringing these fee motions? That's a great question. There's a lot of legal management software out there. I personally have experience with My Case and Clio. Both are great softwares. I'm sure there's others to use, but that's how we've been keeping time, at least at my office.
Yeah, I use Clio Manage for the litigation cases. I use Clio Grow for the pre-lit or on intake side. Super, super easy. You can keep track of your expenses, you can keep track of your fees, and then it'll pop out this report that's very easy to provide in a fee motion.
Okay, what is a reasonable amount to charge per hour? Oh, that's like the $1 million
Yeah.
question. Honestly, I think it depends on experience, years of litigation, years of experience in the lemon law. I think that's all, it's all very personal to the attorney handling the
Mhm.
case. There are some fee surveys out there by Ron Burge you can take a look at. That'll show you what consumer attorneys are charging within California and other states. It kind of gives you an average. That's somewhere where I would start, see where, see where someone in your experience is charging hourly and go from there.
Yeah, and some of the defense firms, like on a recent fee motion, they'll provide their own kind of list or survey of what partners should be charging, what associates should be charging. So take a look at some of those, maybe even pull other fee motions or talk to other practitioners to see if they have those types of resources so you can ballpark.
All right. You mentioned fee motions are way more common. Are you finding that the attorney's fees awarded after filing via the fee motion hearing on average are lower than the pre-AB 1755 days? If so, any sense on how much percentage lower? So I personally have not had to file a fee motion in the last 7 years. Most of the attorney's fees have been resolved pre-fee motion. So now I have a billion to file. So I'm probably not the best person to ask. Michelle, have you had to file any fee motions?
So pre-AB 1755, yes, but I haven't had any since then, since the courts are so backlogged. I'm still TBD on what the response is going to be. But you're also still dealing with a lot of judges just really not liking lemon law attorneys. Like if you've been with CMC, you've probably had a judge that just goes on a rant about, how these cases are silly and should be resolved, and they blame us for everything and for inconveniencing them. So just be aware that's likely on the other side of your fee motion. So from the very beginning, you want to make sure you set up your case and set up your case for a fee motion so that you can show, look, we did everything possible. And this is why my hourly rate should be awarded. And this is why all the work that we've done was because of the other side and it should be awarded.
Yeah, and just keep in mind this litigation is so very new that I'm not sure there's many attorneys out there that have filed a fee motion post
Yeah.
AB 1755 right now. So this is all still developing, and we can continue to
Mhm.
update you guys as this
Yeah.
this keeps going and progressing. But all of it is a work in progress. I've got another question here. How long does litigation take? I want to weigh the options for my client. There is it's a broad spectrum for how long litigation will take, to be honest with you. Before you could say on average cases would
Mhm.
take, 3 to 6 months, 6 to 8 months. Now, I mean, there's no way of knowing, especially if it's a case that it's a legacy case,
Yeah.
may end up going till the first day of trial. It all depends. You can't really give your client any kind of, it would all be guesstimates at this
It
point.
is, yeah, it is. And depending on the facts of your case, what damages you're trying to get, obviously, if you're fighting for a civil penalty, that tends to take a little bit longer. So just take a look at the factors of your case, and just tell your client what the options are, in different ranges. The best you can do is just advise them. It's going to be their decision in the end, whether they want to go pre-lit, do the letter thing, or whether they want to go straight to litigation and kind of buckle up for something that could take several months.
4 years.
Yeah, or more and more years,
More and more years, yeah.
unfortunately.
Let's see. I know you focus on California cases. Curious if you have any sense on which other jurisdictions might have favorable lemon laws that would make it attractive for a uh, lawn lawyer from a business standpoint.
Um,
I'm not, honestly, we're so specialized in California's lemon law that we just wouldn't, I wouldn't even be able to comment on
as
other
a
ones.
non-lawyer, I don't, yeah,
Uh,
this is for lawyers.
for lemon lawyer, for a lemon lawyer.
Okay, good,
Yeah.
good.
So I wouldn't, I know we got it, we got the typo.
We got it.
Yeah, no, I wouldn't even be able to comment on that because we just really exclusively focus on California. So
We
we've
have
got
the
enough to
strongest
deal with,
one, yeah.
you know. We can't know about the other ones.
Yeah, no, we've got a pretty stable, as long as nothing happens with the law itself, we've got a pretty stable industry with all the new technology in the car. So California, very, very strong lemon law despite some of these changes. So definitely a good place to practice if you're a lemon law attorney.
Yeah, and I don't see any other questions, so I
And we're
guess
at time.
we're done here. Thank you guys for listening.
Till next time.